Hello again, this is LegalMate. So we're on to episode 2 now. So you've applied to court, filed your C100, maybe got through MIAM, now you've been given a court date, so you're on your first hearing. If you've never done this before, it's easy to panic or walk in unprepared. In this video, I'm breaking down exactly what happens at your first family court hearing, what it's called, who'll be there, what the judge is looking for, and how you can walk in there calm, clued up and ready. This isn't legal waffle, this is real info from someone who's lived it, so let's get into it. Right, now we're going to go over some key terminology, because before you even step in that courtroom, you're going to have to start hearing stuff that sounds like a different language. So here's a quick no waffle glossary for you. The applicant, that's going to be you, the person who started the case. The respondent, that's going to be your ex, the one responding to it. CAFCASS, that's the family court social workers. They're going to speak to both parents and then give the judge a recommendation. FHDRA, the first hearing dispute resolution appointment. That's going to be your first court appearance. It's going to be more of a chat than a trial. There's also a Section 7 report, a full report from CAFCASS if there's any safeguarding concerns or a proper dispute. This can take weeks, and in my case took months. And finally, an order. That's the final decision from the judge. It can be temporary or final. Knowing these terms means you're actually going to follow what's going on, which is obviously going to help you in the long run. Right, now let's talk a bit about CAFCASS. Barrel of laughs they are. If you've never heard of them before, CAFCASS stands for Children and Family Court Advisory and Support Service, which is a bit of a mouthful to say the least, but here's what matters. They don't work for you, they definitely don't work for your ex, they don't even work for the court actually. They work with the court, and the job is to make sure whatever happens is in your kid's best interests. Before your first hearing, someone from CAFCASS will usually give you a call. They'll ask you basic questions about the situation, things like whether there's been domestic abuse, what contact looks like, and whether there are any risks. This call isn't the time to kick off or slate your ex, obviously. Be calm, clear and honest, because whatever you say can end up in their report. If they think there are no major issues, they'll likely recommend a quick agreement, but if there's conflict, risk or missing info, they might suggest a Section 7 report. That's where they dig deeper and give the court a full breakdown of what's going on at home. Bottom line is, what you say to CAFCASS really matters. They've got a huge influence on what the judge decides, so treat the call like a mini interview and don't blag it. In this situation, they're probably going to be more important than social services. Now let's talk for a second about what judges are actually looking for. When it comes to decisions in family courts, the judge isn't interested in the drama. They're not there to pick a side or dig into your past just for the sake of it. Everything boils down to one thing: what's in the child's best interests. That's the legal test they have to apply, so here's what they'll be looking at. First thing is safety. Are there any safeguarding concerns? Has the child witnessed or been exposed to abuse, drugs, neglect, or anything else that would put them at risk? Consistency. Which parent provides the most stable routine? Judges don't want to disrupt school, nursery, or regular care unless there's a good reason to. Willingness to co-parent. Believe it or not, if you're the one who looks more willing to support contact with the other parent, even if they've been a nightmare, it can work in your favour. Finally, they consider the child's voice. If they're old enough and CAFCASS has spoken to them, their wishes might be considered, but not if they're unsafe or unreasonable. To summarise, judges want to make an order that gives the child the best shot at a stable and loving life, so don't go in trying to win a battle. Go in showing that you're a safer, more child-focused, level-headed parent. Let's talk about you in that courtroom, a bit of courtroom etiquette. You don't need to be a silver-tongued lawyer, but you do need to show the judges that you're steady, respectful, and putting your kid first. So turn up early, dress smart, switch your phone off, and when you're in there, don't interrupt, don't mutter under your breath, and don't react to your ex's lies, no matter how tempting it is. Judges are watching literally everything, not just what you say, but how you say it. Your face, your tone, your body language. Come across like you're fuming or disrespectful and you're handing them ammo to use against you. Stick to facts, stick to parenting, keep your answers short and clear, especially when the judge or CAFCASS ask you something. And remember, the person who stays calm usually comes out on top. You've only got one shot to make a solid impression. Don't blow it by kicking off in a courtroom. So once you've actually made it through this legal version of Takeshi's Castle, what's actually going to happen after the hearing? What are the outcomes going to be? There's a few possible outcomes, and not all of them mean you walk out with a full order straight away. Number 1, agreement on the day. If you and your ex come to an agreement during the hearing, either between yourselves or with CAFCASS or the judge's help, the court can turn that into a legally binding order there and then. Very unlikely. Number 2 is an interim order. This is probably most likely. If things aren't fully resolved, the judge might make an interim order, something short term that covers contact or arrangements until the next hearing. It's like a holding position while more info comes in. Number 3, fact-finding hearing order. If there are serious allegations like abuse, violence or safeguarding issues, the judge might order a separate fact-finding hearing to get to the bottom of things before making any long-term decisions. Number 4, Section 7 report. The judge might ask CAFCASS to carry out a more in-depth investigation called a Section 7 report. They'll speak to both parties, possibly with the child, and give the court a full view before the next hearing. Number 5, final order. If everything's sorted, either by agreement or after several hearings, the court makes a final child arrangements order. That's the one that sets everything in stone, who sees the child, when and how. Not every case wraps up straight away. Some takes weeks, some drag out for months. But if you stay focused, keep your evidence tight and act like a decent parent, you'll give yourself the best shot of getting a proper contact plan in place. This part's going to be crucial. Don't rock up to court thinking that you're going to wing it, because you probably won't. There's a lot of things that you can do before you even get there that are going to put you miles ahead of everybody else. Number 1 is have a timeline of events. Write out a clear, dated timeline, when contact stopped, key incidents, reports to social or police, anything major really. Judges want facts and not rambling. Number 2 is screenshots and message evidence. This is massive. Pull together screenshots of messages that show you've tried to stay involved. Keep it clean and calm. Show you've acted responsibly even if your ex hasn't. Number 3 is your position statement. Draft a 1-page summary that explains what you're asking for and why you're asking for it. Use simple language and not legal waffle. Keep it child-focused. This can help the judge understand your case quickly. Number 4 is court documents. Get your paperwork in order, your C100 application, any responses, your MyAM certificates, your reports from CAFCASS or social workers if you've got them. Don't be the guy turning up with half a folder and loads of excuses. Number 5, last one, is your demeanour. Plan how you're going to come across. Practice staying calm, no shouting, no interrupting. It sounds daft, but it's massive. If the judge sees you as aggressive or defensive, it can undo all of your efforts. You're showing the court that you're serious and prepared and putting the child first. That makes a massive difference when it's time to decide contact. So that's your crash course on what actually happens inside the courtroom. Forget the TV drama, obviously that's not real. The real thing is mostly slow, awkward and confusing unless you know what's coming, but now obviously you do. If you've made it this far, you're already miles ahead of most people walking into that court. Remember, it's not about being perfect, it's more about being prepared. So keep learning, keep calm, and don't let anyone tell you can't handle this on your own, because that's how solicitors make their money. Drop a comment if there's a specific bit of this process that you want me to break down, and subscribe if you want more no-nonsense legal guidance without the legal waffle. I'll catch you in the next one.